Have you ever thought that transferring property to your spouse or family is just a simple personal decision? Under Canadian income tax law, that same transfer could make you responsible for someone else's tax debts. Hi, I'm Amandeep Singh, CPA and founder of Cloudiverse CPAs. Today, I'll walk you through Vasilkioti versus the King case, decided in July 2024, which shows how Section 160 of the Income Tax Act works and why documentation and planning matters so much. Here's what happened. Marilyn Vasilkioti's husband transferred his 50% share of their Toronto home to her back in 2012. And at the same time, that share was worth about $240,000. Years later, the CRA reassessed her personally for over $72,000, claiming her husband had unpaid taxes from 2007 to 2011. The position was that she gave little or no consideration for the transfer, and therefore she was jointly liable under Section 160. But the case did not just stop here. The court reviewed the evidence closely. CRA had relied heavily on internal documents called T1 case printouts, which turned out to contain errors and inconsistencies. The collections officer admitted she never reviewed Mr. Vasilkioti's tax returns or actual notices of assessment, even though she did have access to them. And that was a big problem because one of the legal tests under Section 160 is that the transferor must actually be a tax debtor at the time of transfer, and CRA simply could not prove that. Even if her husband did owe taxes, Mrs. Vasilkiotis had another strong defense. She had provided real consideration. Over the years, she had loaned her husband and his company Aegis about $279,000, and some of this was documented through checks, bank statements, and even mortgage payments she alone had covered. Other amounts came from her personal bank account to pay off business lines of credit. While there was not a formal loan agreement or interest charged, the court accepted her testimony as credible and reliable. The loans were legally enforceable, not just moral obligations. The court concluded that the value of her loans exceeded the value of the property she received. In other words, this was not a free transfer, this was a repayment of debt. The outcome? Her appeal was allowed with costs and the assessment was vacated. Now, what's the lesson for business owners and families? You see, Section 160 is one of the CRA's most powerful collection tools. It does not require proof of intent. If you transfer property to your spouse, child, or even a corporation you control, and you owe taxes to the CRA, it can go after the transferee even years later. But this case also shows how good documentation can protect you. Bank records, written loan evidence, and even credible oral testimony can be enough. The stronger your paper trail, the stronger your defense. At Cloudiverse CPAs, we help our clients structure property transfers, shareholder loans, and family loans in a way that stands up to CRA scrutiny. We make sure repayment obligations are clearly documented, amounts are traceable, and that you don't unknowingly expose your spouse or your loved ones, your children, to your tax risks. So if you are considering a property transfer, or if CRA has raised a Section 160 assessment against you, reach out to us. The right planning now can save you years of stress and litigation later. I'm Amandeep Singh from Cloudiverse CPAs. Thank you for watching, and remember, when it comes to family and taxes, clear records are your best protection. I'll see you in my next video. Bye.